before the court is, I have no idea how to pronounce it, Creque?
Creque.
Creque, okay, I was gonna be close, versus Oippolo.
App.No. You're in the ballpark though.
Sorry about that. Well, at any rate, you each will have 15 minutes to present your arguments, and the appellant may reserve up to 5 minutes, and just let me know.
Thank you.
Your Honors, I am Leslie Rose for the appellant, and I would like to reserve the 5 minutes.
Thank you.
Your Honors, this action came about as a result of the appellant not receiving child support for a period of several years. When that happened, CSCA was contacted, the situation was rectified, the appellee was notified that he would support, and shortly thereafter, there was an incident involving a minor child that dealt with drug experimentation. The appellant contacted the appellee father, I represent the mother, and let him know the situation and wanted to deal with it. His way of dealing with it was to file a motion to modify custody. She then filed a motion to modify support.
Counsel, I want to interrupt you. I neglected to inform you that we always use initials or just refer to the child as the child. Now, I understand the child is emancipated at this point, but during this, thank you.
Okay.
I'm sorry for
And
interrupting.
so the appellant and appellee, you don't want those names either?
No, that's fine.
That's fine.
They're adults.
In any event, this started court proceedings. All along during this time, there were many, many negotiations, discussions of settlement. In fact, we had thought that we had a settlement up until the end of trial. When that didn't happen, we started a trial, and this is where I have my assignments here. The trial lasted 1.5 hours. It was a custody trial. It was a trial over support. There was discovery done towards the end of the case because, I thought we had it settled. During the trial, it came to be understood that the appellee knew that there was discovery request and just blatantly ignored them and chose not to.
Okay, when was the discovery filed?
The discovery was filed about a month before the final hearing date. And it is true that it was later, but there was nothing preventing me from filing it. There was no order that said it had to be filed. There was no pretrial order stating that there was a deadline to file it. And it is common practice that attorneys know when there are support issues that they are to bring the income information of their clients. That was not done.
You need to bring it to court.
If you file a motion to modify support, there's orders issued that you give to bring your income information. That was not done.
Was it filed a month before when the trial was originally set, or when the date when the trial actually happened?
The date when the trial actually happened. Then we really thought that it was settled. So, there was a lot of expense involved, and that was part of it. In any event, the appellee really made out by not being required to supply his income information because we just had to rely on his word. He did testify that he earned $100,000. When the hearing came about and there's this small amount of time and the whole thing was just very rushed. The magistrate announced that we were going to each get these 45 minutes. The appellee testified, presented his case within the 45 minutes, and then when it came time for the appellant to testify and bring forward her case, he was able to further infringe on her time during that time. So the time was not equal. The time was cut short. The hearing was abruptly stopped, and we were told, you can't talk anymore. And to argue a custody matter and all the pending motions that were before the court financial, there just was not enough time, and it's clearly, to me, an abuse of discretion. With regards to the findings by the magistrate. The magistrate did not even address the motion to modify support. The judge then overruled our objections. There was never language regarding child support worksheets, why it would not be, supporting why it would not be modified. The reason given was that there were in-kind contributions given by the father that would take care of any modification. However, we never knew what the modification would even have been. And those in-kind contributions were things that really never happened. The child never received a car. The mother should have received a car in any event, because the support that the modification that she was trying to get was from a date prior to a car even surfacing. So how does the mother get compensated for money that she had to come up with prior to a car materializing? During that time, the mother lost her house in foreclosure. She had a lot of financial issues because she wasn't getting supported. It's true that once the court came to materialize, there was, in the court proceeding, the father did eventually pay a lump sum of support that he owed. But again, that had nothing to do with the modification. That was just support that he had not paid for years. He was found not in contempt merely because he paid it. Well, there was no time to put on anything about fees. There was just no time to do a lot of things that should have been done in this hearing.
Was she damaged in other ways, other than just attorney's fees?
Well, she was damaged in that she lost her home. In foreclosure, she couldn't make the monthly payment. She couldn't afford for her child to do certain things. She did have some assistance from a friend who helped pay for things, and she owed him money, so there's that issue there.
Of course,
Yes.
the other side to that is, the argument from the appellee is that she inherited $50,000 and put that toward a mortgage. So it could be argued that she just made lifestyle choices.
Well, we never even got to address that because there was no time. And so that was just his assumption that she had that sum of money and that there really was no proof to that, and there was no evidence as to exactly how the money was spent, because it was more important for her to talk about the modification, what the incomes were, the custody issues, and so forth. So he made a lot of.
Did appellant object to the amount of time? Because evidently it was in the notice that you would only have like 2 hours maybe, or an hour and a half or something like that, when you received the notice.
Well, we were told that when we came in, that we would only have that amount of time, and.
So you didn't receive a written notice that indicated how much time you had?
No, we did not.
And did you object at that point?
You do receive notices from the court as to like times, but it's typically, if you don't finish, then you set it for a new date. And we were told that if you get a new date, this could be months later, and just that morning, he said, no, we're gonna finish it up today, and that he did not do on the record, but that is what happened, and then he just hurried us along throughout the whole hearing, and that's what happened.
So there was no objection?
Well, there was no objection that shows up on the record, but I did object to the time.
That's fine.
And I certainly wasn't aware during the hearing as to the equalization of time, because I didn't keep a running clock running as to what I was getting and what he was getting, but I did object, I believe, during the time, the second half, when he was appellee was continually allowed to interject and into my client's time frame. So that did happen. With regards to the support, again, another thing that happened was they were both responsible 50-50 for the medical, and none of the statute was followed in modifying the child support. The custody was based by the magistrate, it was just based on a possibility. He did not review the factors. I'm not so sure that even the factors were put into the record with regards to finding custody, all of the factors. And he based it just on, well, maybe the father will do better. The parties did stipulate to the guardian ad litem's report, which was an agreement that,
Counsel, I want to interrupt you because you've already your 5 minutes. If you want to save them, if you want to continue, you may.
thank you.
Your Honors, my name is Dean Kalovis. It's very nice to meet all of you. Would it be out of line for me to ask you to give me a warning when I have like 3 minutes to go?
I can, but it's not like you get rebuttal unit.
I know I don't get one. I just want to know when I
Just
should
going to be
start
evidence,
wrapping
that's
things up.
fine.
Okay.
I'll do the best I can, let's push you that way.
Thank you. And I apologize if I have a cough drop in my mouth because the alternative is going to be me losing my voice a lot.
Everybody seems to have cough drops in their mouth.
I would, just to respond to a few of the specific statements that were made by opposing counsel. First of all, as far as anybody objecting to the amount of time that this case was set for hearing, the answer to that question is there was no objection to the amount of time of the hearing. I didn't object, they didn't object, nobody objected. To put this in proper perspective, Your Honors, this case had been in front of Magistrate Stephen Collins. Granted, on this day it was for 2 hours or an hour and a half or whatever it was. He had been involved in this case literally for 15 years. If you look at the court docket, I think the first filing in this case was back in 2002 or 2003. There was always something in his room. These people were parading in front of him for many, many years regarding this child.
But on that particular day, he had, what, 3 or 4 motions?
Well,
a year?
that's a little bit of an exaggeration. There were technically, the emergency custody motion that had been filed that was a moot point. That was no longer before the court. There was a child support modification motion. There was a motion to compel discovery. But as far as the motion to compel discovery is concerned, this case had been scheduled for trial on 2 prior occasions. It was continued once at my request. It was continued once at appellant's request. There was never, ever any request for any discovery information before either of the first 2 trials. And they were continued in reasonable proximity of the trials themselves. The first discovery request was issued exactly 28 days before the date of trial. And when we went, and I believe that the local rules of Summit County provide that if there's a motion to compel filed, it has to be filed within 7 days prior to the date of trial. There were no, it was something that, with all respect to opposing counsel, it was an issue that was, it just never really that fully explored. And that's why things ended up the way that they did. As far as the support is concerned, I mean, I don't know what opposing counsel means when they say that we don't know if the child ever received the car. The record is replete with incidents talking about the child driving in the car. She got the car. It was a $10,000 car. My client additionally would pay for her auto insurance. He additionally paid for half of her tuition. All of this was in addition to his child support.
Why wouldn't that be regarded as just a gift? He's under no obligation to do that. So
Well,
why does he get to determine how extra money that maybe the child is deserving under the support regulations to spend it in the way he seems to, instead of mother and daughter and father deciding that?
That's certainly a very legitimate question, and I would like to, if I did not make it clear in my brief, and maybe I didn't, I'd like to address it now. There are other factors that were set forth at the time of trial, which the court does have some discretion as far as determining it to be a gift. The mother, if you'll see in the record, had a bad gambling problem. She was thrown out of the casinos downtown a couple of years ago. She's now no longer banned from them, but she was tossed out of the casinos. The mother, there was testimony, and it was testimony from the mother that she received $50,000 from her inheritance back in 2014. The mother had not worked in 10 years. She had this friend, and I'm not saying that in a bad way, he's kind of a mysterious individual. I don't think they were involved in a romantic relationship, but this gentleman, Bruce Boucher, would always help provide her with some kind of financial assistance. The mother has a prescription drug issues, she has gambling issues, she's
Counsel, if you don't mind, I'll stop you if you don't care.
No, that's
Yes, I read all that, but I guess what I'm wondering is, did the court say mother can't be trusted with the funds, or did the court just say, well, dad gives all this extra money, so therefore it exceeds the amount of money that he would have to pay in child support?
The court did not necessarily link the two together in its arguments, but it made findings along the way. It indicated, it recognized the fact that mother had the gambling problem. It indicated the fact that mother had the prescription problem. As far as the portrayal that mother was behind in her mortgage because she wasn't getting the support was about, I don't think it was more than $300 a month. The mother hadn't paid for the mortgage on that house in years. Years she hadn't paid for the mortgage on that house. It had been sitting in foreclosure for a while, and I think things were just starting to bubble up a little bit around the time of hearing. But it was a situation where, due to the foreclosure, there was a necessity for this child to have a vehicle so she could get to school, because we didn't know where mother was going to end up. So there had to be a situation where if this child was going to go to school, she had to have a car. So that's something that weighed into the equation also, because the transportation was necessary for this child. As were issues of insurance, as were issues of he would give the child spending money. I will concede that the magistrate did not directly make the link in his findings, but by the same token, he did include those issues in his findings. It's something that he was keenly aware of. He, as far as mother, I believe there's Supreme Court case law, and I've cited it in my brief, that talks about the discretion of the trial court when making decisions in custody-related matters. And this magistrate was so very keenly aware of these individuals and what they brought to the table. If to be at the trial, a couple things that it's hard for me to explain in the time allotted. You had a situation, it's referred to as, we're talking about drug experimentation or a one-time incident. This was a horrible, horrible thing that occurred. This child, it was a combination of a mix of acid and Xanax. It's potentially lethal. All right? It occurred at a party at the mother's house where the mother was out with her ex-husband. She left a 21-year-old and a 23-year-old in charge of the crew at this party, and there was no...
How old was the daughter at the time?
I'm sorry, what?
How old was the daughter at the time?
I want to say she was either 16 or 17, one of the two. Okay.
And there was testimony about the party at the hearing?
I'm sorry. Could you,
Was there testimony about the party at the hearing?
absolutely, there was testimony about the party. It was on social media. This got put on social media.
Did the mother know the party was going to occur that night?
Yes, the mother said she said I left her other daughter, I'm not passing judgment on people, but has a child out of wedlock at age 21. That's one of the people who was in charge. And then there was another niece or something, who was her friend who stayed at the house, who was like 21 or 23, who I think had her own issues, who was in charge. The reality of this situation, the mother, when these folks were in front of Magistrate Collins some years prior, okay, there was an issue where a boyfriend of can we say her name now that she's an adult? No?
No.
The boyfriend of AK was sending pictures of his genitalia to her. She was strictly forbidden from seeing this gentleman, this boy. At the hearing, the mother was saying that she doesn't see the boy. Then she was saying, I'm afraid that she's seeing the boy. Then she acknowledges the police came up to her talking about her seeing the boy.
Counsel?
Yes.
Could I interrupt again?
Sure.
Because we have such limited time, so I
Absolutely.
apologize. But it seems like everything you're arguing about is the custody decision. And isn't that really a moot issue at this point?
Oh, absolutely. As far as, if you would like me to limit it to the support, I would be glad to.
Well, it's your time, but I'm just wondering.
Well, I didn't know how you guys evaluating this. No, as far as the support issues are concerned, regarding the contempt motion that was filed, That was taken care of at the very first hearing within 5 minutes. There was a contempt motion. There was never a bill submitted as to fees that were incurred in that motion. The actual court time that was taken to handle that was about 1.5 minutes, because my client brought all the money to make things current right at the first hearing.
Well, there was a request for attorney's fees.
I'm sorry.
There was a request for attorney's fees?
I don't know if it was in the original motion or not. Even if we assume that it was, there was never, this case was lingering for over a year, or about a year.
But it was set for hearing that day.
It was set for hearing that day, and it was set for 2 prior hearings. And on top of that, all throughout the pendency of this case, there was never a bill submitted. We had several hearings.
But couldn't they have submitted that bill at the hearing if the court would have heard that motion?
There was nothing precluding that bill from being submitted at that hearing. I want to stress there was, and I'm talking fast now because I know my time is starting to go a little, there were no objections as to the time of the hearing. The amount of time that it would have taken to submit a bill would have literally been 30 seconds to submit a bill for the contempt motion. It was never talked about at any of the prior hearings. As far as saying that we infringed on, and I want to address this issue, we didn't infringe on anybody's time. The infringement is that we cross-examined one of the witnesses that was called by appellant. That is hardly an infringement. That's a right to see them cross-examine a witness.
I'm going to interrupt you again, and I apologize.
No, do as much as you want.
This is probably not necessarily a fair question, but the moment I started reading this case, I thought about a prior case that I authored, Bohannon versus Bohannon. I don't know if either side's familiar with it, but we reversed a case where the domestic relations court in Summit County only gave the parties an hour and a half. Is there any way, if you're not familiar with it, that's fine. I just want to see if there's any way you can distinguish it.
Well, the way I would distinguish it, 1, nobody objected to the time limitation. 2, there were no proffers made at the end of the hearing as to any additional evidence. Even within the body of the brief itself, there are no discussions of anything additional that would have been brought to the attention of the court. The mother claimed that she was doing a few things, taking her to colleges, keeping an eye on where she went. There was no additional proffer offered as to what mother was doing. There was no real indication that there were no other witnesses waiting outside to be called. Okay, there was no indication that there was additional evidence that had to be offered. As far as the lack of evidence offered in the child support matter, that wasn't because of the fact that there wasn't enough time. That was because of the fact that there was no discovery done. That wasn't my client's fault. There was no discovery done. There wasn't a proposed child support guideline offered into evidence. There was nothing. And I mean, I'm not going to sit here and insult the intelligence of anybody. The magistrate could have been more complete in his decision. I'm not denying that. But if you read the various findings that he had and you apply it to the facts of this case, he made findings to the fact that he believed that mother had some issues that would imply that she is somewhat irresponsible. He made findings to the effect that father provided approximately $20,000, if you add it all up, of payment of expenses that were necessary for this child or for the benefit of the child, and was money that he couldn't necessarily be 100% certain mother was going to use in a prudent manner. Okay, because mother hasn't had a job for 10 years. She's not on any kind of disability. She has a pill problem. She has a gambling problem. There comes a point when she's living in a home that she hadn't paid for, wasn't intending to pay for, wasn't trying to pay for. There comes a point where somebody can say, what do I want to do with this money? Do I take this money and just give it to somebody who's going to do whatever with? Or do I make sure that this money is strictly earmarked and used for the benefit of my daughter? Okay, when we're talking about a car to get to school, when we're talking about money to pay for an education, keeping in mind also that the child had to go to Holy Name, because if the child was going to go, if the mother was going to have to relocate, that would mean the child would have to go to a different school. The father was doing things to assure that his child be able to maintain her education, assure that she'd be able to get to school. Those are the things that were important. Yet, could he have given the money right to the mother? I highly doubt that the use of that money would have inured to the child. This isn't like he went out and bought her a bunch of clothes or sent her on a vacation somewhere, because he did stuff like that too. He would take her to Florida, but he's not asking for any of that. We're looking at specific things that were for basic needs of the child. And those are things that the magistrate, although he didn't necessarily connect all the dots in his report or his decision, he made the findings of that those facts existed. And these are all significant important things in the day-to-day life of a child. And that's why the decision was made as it was. In fact, even if there were to be a calculation of the child support, any increase in child support would pale in comparison to this additional money. That even if his child
How do
support.
we determine that if we don't even know how much he earned?
Well, he testified, he gave a testimony as to how much he earned based on, when the question was asked. But again, as far as, and again, I'm not trying to throw opposing counsel under the bus, but that, when she's saying, oh, we settled it, oh, we were about to be done, do we want to get into reasons why the case didn't settle? That's a whole different story, and it's not my client's fault, I'll tell you that right now. So, this is a situation, and I hate to say this in a bad way, this is somebody who right now, and it's the reason she's still here, is still reaching her hand out. She's reaching her hand out, she wants money from my client, that's why we're here today, that's why these appeals were filed, that's why objections were filed. Originally, the child was lost in the shuffle. There was no child support modification filed until my client filed a motion. It's not as though
Thank you,
she,
counsel.
I'm sorry, what?
I'm sorry, thank you.
Oh, no,
You're
I
out
was
of
talking
time.
real fast, but
That's
I
okay.
don't normally go that
I'm
fast.
a fast talker too. so-
All right, I'm sorry, thank you very much.
Thank you. You have 5 minutes, right?
Thank you, Your Honors. As far as the magistrate making rulings based on the prior history, both of these parties did have checkered histories. My client did have a history of past drug abuse. She did have gambling issues in the past. The father had domestic violence issues and drug issues in the past. In fact, his prior motion to modify custody was dismissed because he refused to take a drug test. So the guardian ad litem, her job was to look at the current situation. She did look at the current situation, and there was no drug usage going on by the mother, and there was no gambling issues going on by the mother, and she actually recommended that the shared parenting be put into place with the mother being the primary residential parent. So, with regards to the support, the mother never received $10,000. The daughter never received a car in her name. The father continues to have control over the car, it belongs to him. So he never really gave $10,000 to either the mother or the daughter, even though the mother was really the one entitled to it. There was no evidence that he ever paid the automobile insurance, and to this date, I don't believe that he is paying the automobile insurance. With regards to my client having notice of a party, she never left her daughter with the intent that she could throw some kind of wild party. Her daughter had a couple people over. It wasn't a big party, and yes, they did something wrong. They experimented with drugs, and it was a one-time thing, and she went to the father to get help. The father, who testified that he works 100 hours a week and was never around, never available for years, all of a sudden is Mr. Great Dad be involved with the child. With regards to whether a friend helps her or not, there was really no significant testimony on that amount, but that's something that he shouldn't be required to do, and she did testify that she borrowed the money from him and does owe the money, and I believe she did testify too that some of that inheritance she did pay back to him because he had been helping her for years with her kids when the father wasn't. The father also did have about a $350 child support award, but at the time that he stopped paying it, there were 2 minor children, so that was closer to about $700 a month that she wasn't getting. She got her $10,000 during the proceeding, during the pendency of the case. There was no evidence that she went and gambled that money away that she was entitled to get. However, she did get that after the foreclosure. She testified that she lived in a new home. The school was a private school. There was no issues regarding change in location because of the school issue, because you could live anywhere and continue to go to the private school.
But counsel, that, again, as I said to the other side, isn't that going to the custody issue, which we really don't have a force anymore?
That is true. But as far as like financial stuff, she was still gonna go to that school, and the mother actually helped pay for the school too. So she didn't have the qualifications and the ability to earn like the father did. He decided what he wanted to say was his income. There was no verification of it. He's recently purchased a Ferrari and a Cadillac, now the whole thing's over.
Council, no objections here, but I was just gonna say to you, we don't talk about anything that's not in the record, we will not consider it.
Well, there
So
were
both of
lots
you have done that,
things-
and to be honest with you too, both of you kind of make some character assassinations, it's not really necessary, not professional. And I just, I let it go, but I just want to tell you, when you're in the Court of Appeals, we don't appreciate that, or at least I don't, I won't talk to these other people.
I don't believe I did that in the first half, but there was a lot of that going on in the Pelley's argument that is just not true and not even in the record.
That's fine, we will only consider, I want to assure both of you, we will only consider what is in the actual record.
Does the record contain the discovery requests that were the subject of the motion to compel? Do you understand what I'm saying? Or does it just say?
There is testimony that the defendant admitted that he did receive the discovery request.
But as far as the actual requests that were forwarded, the documents requesting discovery?
It wasn't filed with the court, but
Okay.
the defendant admits in the transcript that he received it and that he was aware of it and he knew what it was, and he just, actually he questioned his attorney during the proceeding.
Then is there testimony regarding what was in the discovery request? I'm trying to understand if the discovery requests were related to the support issue.
The discovery request was related to all issues, support, exhibits, and all that kind of stuff. And we did not have time to submit any exhibits at the end of this hearing because it was cut off.
And counsel, you are out of time, but I want to make sure that Judge Hensel is satisfied. Thank you.
Thank you.
I have no questions. Thank you.
Thank you. The court will take the matter under advisement, and we appreciate your arguments, and we will issue a written opinion that will be sent to both sides. And you can also look at our website and on the Supreme Court website. Thank you very much. I hope you both have a good day.